I'm attorney Marc Pelletier, and this video will discuss strategies for defending a felony charge in Florida. There are a number of things that our office can do in order to help on a felony charge. First, and perhaps most importantly, it might be necessary to intervene early with the state attorney's office. Just because you have been arrested for a certain charge does not mean that the prosecutor has to proceed with that particular charge. If we can intervene early with the state, there are times, depending on the facts and circumstances of a case, where we can convince the state to file a misdemeanor charge rather than the more serious felony charge, or perhaps convince the state attorney's office not to proceed on any criminal charge at all. You may be eligible for what's called diversion, or pretrial intervention, also referred to as PTI, where you complete certain tasks, and in exchange, the state attorney's office agrees to dismiss that charge, given your prior limited criminal history. You may be eligible for a departure, where we seek to have the judge not impose a state prison sentence based on a specified legal reason, even though the law otherwise would require it. There is an opportunity to avoid felony conviction by obtaining what's called a withhold of adjudication. This allows the court to impose sanctions against a person, but it also allows that person to avoid becoming a convicted felon. A withhold of adjudication avoids a driver's license suspension, the loss of civil rights such as the right to own, use, and possess a firearm, the right to vote, and the right to sit on a jury, and it can also avoid certain difficulties associated with regulated or licensed professions. And finally, in situations where we achieve the right result, we may be able to go on to seal or expunge your criminal history so that none of the information associated with the prosecution appears in the official public records whatsoever.